Back at the office, Jose?
Oh yeah, we're being in office. But it looks like my office.
Well, it doesn't look like your living room, like the last few calls.
Yeah, there's no art in here. Yeah, no, I mean, we're in the office. I mean, we're just, staying apart and wearing masks all the time.
We had a little breakthrough case scare at our office, so I'm at home today. But I got tested. All is good.
Good. Yeah, we had one. We had one last week as well. And everybody got tested and it was great. I mean, nobody got it. So it's good. Well, everybody's vaccinated, so even the one that had it, had very, very mild symptoms.
Hey, Emily, I don't know if you saw Alfonso's email earlier, but he said that he'll be a little bit late. I think we'll be fine on quorum, but just wanted to give you a heads up.
Thank you. All right, I think we are ready to get started. I'll pass it over to you, Valerie.
Good morning. I would like to call the Monday, August 16th Board of Adjustments meeting to order. We will begin with roll call. Candace Forrest.
Present.
Todd James.
Present.
Tamara Aggins is absent. Jose Alvarez.
Present.
Ramiro Diaz is absent. Alfonso Gonzalez. I'm sorry. Is Rami there?
Yeah.
Mm-hmm.
Oh, I'm sorry. Alfonso Gonzalez
He's running late.
is absent. He's running late. That's right. And Matt Rufo.
Here.
Okay. At this time, would the board make a motion to adopt the minutes from the July 19th meeting?
I, Todd James, so move.
Alvarez seconds.
It's been moved by Commissioner James, second by Commissioner Alvarez to adopt the minutes from our July meeting. Our roll call vote, Todd James,
Yes.
Jose Alvarez,
Yes.
Ramiro Diaz,
Yes.
Matthew Rufo,
Yes.
and Candace Forrest, yes. 5 yeas, no nays, the motion carries.
Okay. Would the chairwoman please read the special hearing rules for adoption?
Yes. Special public hearing rules for Board of Zoning Adjustments hearings held via video conference. Order of business. The order of business at the hearing shall be as follows. Call to order and roll call with recording of members present, approval of minutes, reading and adoption of the hearing rules, presentation of dockets, which includes staff presentation, applicant presentation, and questions from members. Recess for 30 minutes. Consideration of dockets, which includes public comment, rebuttal by applicant, questions from members, and voting, ending with adjournment. Presentation of dockets. The order of business for each docket shall be as follows. Presentation by the City Planning Commission staff or the Department of Safety and Permit staff. Presentation by the applicant or their representative. The appellant or applicant may appear on their behalf or be represented by a duly authorized agent. Only one representative may speak on behalf of a request and must pre-register with the staff of the City Planning Commission. Other representatives or speakers may sign up to provide comments during the public comment portion of the meeting. The applicant shall be allowed a maximum of 5 minutes. Questions from members. The members have an opportunity to ask questions of the staff or applicant. Recess. The board shall take a 30-minute recess to allow members of the public to submit comments. Public comment, rules. Only written public comment will be allowed. Live public comment will not be allowed. No member of the public may submit more than one written comment per agenda item. Time allowed for public comment. The public comment form will be made available at the start of the meeting and will close at the end of the 30-minute recess. Form. Public comments must be submitted electronically on the form provided by the City Planning Commission. Any comment missing this information will not be read aloud. Each submission must contain the commenter's first and last name, the commenter's address, whether the commenter is being paid in connection with his or her comments, and the agenda item. Reading of public comments. A moderator will read into the record all comments pertaining to that item that have been submitted in accordance with these rules. Comments will be read aloud in a normal speaking voice. The moderator will discontinue reading a comment once it exceeds 2 minutes. Rebuttal by applicant. Following the public comment period, if there is opposition, the authorized representative of the application is allowed a rebuttal not to exceed 5 minutes. Questions from members. Following the public comment and rebuttal, the members have an opportunity to ask questions of the staff or applicant. Voting. Making a motion. The member making a motion shall clearly state their name when making a motion. For example, I, Candace Forrest, move to approve or deny the request. Seconding the motion. The member seconding a motion shall clearly state their name when seconding the motion. For example, I, Candace Forrest, second the motion made by the other member. Statement by the chair. The chair will restate the motion, confirming who made and seconded the motion. Voting. The chair will request a verbal vote from each member by roll call. Each member will indicate yay to vote in support of the motion or nay to vote in opposition. This concludes the hearing rules.
Thank you. Would the board make a motion to adopt the special hearing rules?
I, Todd James, so move.
Alvarez seconds.
It's been moved by Commissioner James and seconded by Commissioner Alvarez to adopt the special hearing rules. Roll call vote. Todd James,
Yes.
Jose Alvarez,
Yes.
Ramiro Diaz,
Yes.
Matthew Rufo,
Yes.
and Candace Forrest. Yes. 5 yeas, no nays. The motion carries.
Thank you. In accordance with the adopted hearing rules, the public comment form link is available on the city's Granicus website, as well as on NOLA.gov/CPC. It will be available until the end of the recess, after which public comments will be read into the record as a part of consideration of dockets. As a reminder to applicants, action that the board takes today will be released in the form of a disposition notice by August 26th, sent via email, mail, and posted on the One Stop app. Requests that the board votes to approve must show compliance with any noted provisos before the case is finalized and granted final approval. Items 1, 2, 4, and 6, BZA dockets 05621, 05921, 06221, and 06321 have all been withdrawn. We will begin with unfinished business for variances. Again, item number 1, BZA docket 05621 was withdrawn by the applicant. Item number 2, BZA docket 05921 was withdrawn by the applicant. The next item is item number 3, BZA docket 060 for a property at 2315 through 2317 North Robertson Street. Following the staff presentation, the applicant will have 5 minutes to present. Amir Mohammed is signed up to speak on behalf of this application. And following the staff presentation, the applicant will have 5 minutes to present. Haley?
This request is for a variance from the provisions of Article 21, Section 21.6.AA.1 to permit the conversion of a single-family residence to a two-family residence and in addition with a porch with insufficient setback from a side lot line. Uncovered porches, including attached steps and stoops, may be located in the interior side yard, but must be a minimum of 2 feet from any lot line. The porch is located 10 inches away from the side lot line, and the applicants are requesting a waiver of 1 foot 2 inches. The staff found that the requested variance for a porch with insufficient setback from a side lot line fails to meet 7 of the 9 criteria, in that there are no special circumstances which are peculiar to the land. Literal interpretation of the ordinance will not deprive the applicant of rights commonly enjoyed by other properties. The special circumstances were caused by the applicant. The variance will confer on the applicant special privileges. Granting the variance will alter the essential character of the locality. The property regulations will not result in a demonstrable hardship, and the change is exclusively for the convenience and profit of the owner. Therefore, the staff recommends denial of the requested variance.
Sana,
You have 5 minutes to present, Mr. Mohammed.
yes, good morning. This is Muhammad, and I hope you guys have the paperwork to see a picture. Can you guys hear me?
Yes, we can.
Yes, so to just get an idea, if you guys can see the picture, I think that is on the slide 17, on the page number 17 in the document. In that it clearly shows how it is laid out and what I'm asking for. It's a side access to the building, and that is it's a side access to the building, and that has 10 inches from the fence line. I'm asking for 1 foot 2 inches variance, but it's just an extended landing. It's not going to block the firefighters or anything in way, and that landing is having a crawl space underneath. So it's just a concrete slab of 4 inches thick, just running across with 18 inches of being height. It will not bother the neighbor, and it will not, because of this, there would be no runoff water will get stopped because it has a clear access through it. There is a crawl space underneath, and no objection to the firefighters because they still have enough access to get into the back of the building.
Is that the end of your comments, Mr. Mohammed?
Yes, ma'am.
Thank you. Are there any questions or comments from board members?
Just a quick question of staff. Staff, is in this area, I know it's a 2-family district. Is multifamily allowed at this parcel?
Yes,
Multifamily is allowed?
not multifamily, I'm sorry, the 2-family. They went from single family to 2-family, and multifamily is not allowed.
Okay. Only reason why I'm asking this, and I'm not going to belabor the point, but just something I just have as a moment of pause when I'm reviewing this plan. When I'm looking at this and where he's proposing this landing coming up the side access, the plan itself almost shows as if though it's ready to be reconfigured to be more than 2 units, especially with these side doors going into these primary rooms. They're trying to apply it as a single unit. But just from the plan is behaving as if though this is going to be almost like a 4-plex as opposed to 2, and that's why they're trying to create this side access on the property. So I'm only saying this because I think it only further echoes the reason for the denial, but just from the behavior of the plan, it just really doesn't speak to. I really don't see a justification of why this landing is being created and needs multiple points of access to the side of that single unit. Not sure if anybody else sees what I'm looking at, and I'm not seeing where the second floor plan is even proposed. I think that second floor will probably be pretty telling as to why this is being configured this way.
Yeah, Todd, I see what you're saying, and I'm wondering why there isn't just a door on the back at the
Right.
stair. I know it looks like there's maybe a window in the elevation, but
And-
that could
yeah.
easily be a door, and then you don't need the side porch at all.
And even when the floor plan, the way it's shown in the floor plan, it's presented as windows where the doors are drawn in. Where at least the pictures show doors, but the plan is drawn like a window. So it almost looks like bait and switch. That's all I got for you, Madam Chair.
Yeah, I was gonna get into more questions when we get to the second portion of the meeting, but I kind of had similar questions and just trying to understand why the request would be needed and specifically around what would be the hardship by not granting the request. So that was, I mean, we can talk about it now, but that was kind of the questions I was going to address in the second part of the meeting.
Just rather bring up what I think is a critical talking point before we get to the second half.
Understood. Any other questions or comments from board members?
Yeah, I just have a follow-up on that. Since this is assigned as after the fact, I would assume that the original building footprint didn't have that side porch.
That's correct.
Okay. And in those floor plans, I don't see them in the original deck. So it was just, I was just wondering if there were doors on that side in the original planning.
That I would have to confirm.
Yeah.
This is, it actually, so Jose, just looking at just from the plan, this is all new construction added onto the back of the property. It was a single family building in the front, and this is almost like 3 or 4 units being added to the back of the property.
And that's what I was going to mention, Commissioner Alvarez. It was a single family originally, so a lot of this is in addition. And Commissioner James kind of mentioned it already, Haley. I was just trying to confirm because the way that the request was written, I was making sure that the only thing before us is the addition. The conversion to a 2-family unit is not anything for us to consider. It's just the addition, correct?
The only thing we're considering is that they have a porch in the interior yard, and we're considering that it's located closer than 2 feet to the lot line.
Got it. Okay.
So, Madam Chair, the reason why I brought up that point, asking the question if multifamily was even allowed, I'm just trying to highlight something that I see in the plan that I really think I think that's really the crux of why this is even in front of us.
Right. Well, the request read that it was a variance to permit the conversion of a single family to a 2-family the addition. Right. So that's why I was just making sure that that conversion wasn't anything that we were considering, just the addition of the porch.
It's the porch. All right.
Any other questions, board members? Seeing none, we can go to the next item.
The next item, item number 4, BZA docket 06221 was withdrawn by the applicant. The next item on the agenda is the consideration of officers, which was deferred from the last meeting. In accordance with the BZA rules annually, the first meeting on or after July 1st of each year, the board shall elect members from its members a chair and a vice chair, and shall deem necessary and proper. The chair and vice chair shall serve until June 30th of the following year, or until the successors have elected and qualified and may, if duly elected by members, succeed themselves. Is this something that the board wants to consider right now or move to the end of the meeting?
You are muted, Commissioner.
Yeah, thank you. I know just what we've done in the past, we always kind of take this up as like the last agenda item on the meeting. So maybe if everybody's okay with entertaining a motion to suspend the rules and move it to the last item on the docket.
Yeah, and I was also going to point out that we're missing a member who will be joining us. So,
Correct.
Okay.
With that,
So,
are you making the motion, Commissioner James?
Yes. So, Madam Chair, with that, I'd like to defer the election of new officers to the end of the meeting to allow, I know that we're still missing one board member today, but I think we could likely move forward with this. I know we pushed it back last month because the chairwoman was absent.
I'll second. Rami, we'll second.
It's been moved by Commissioner James and second by Commissioner Diaz to suspend the rules and defer the consideration of officers, election of officers to the end of today's meeting. Roll call vote, Todd James.
Yes.
Sorry, I lost my page. Ramiro Diaz,
Yes.
Jose Alvarez,
Yes.
Matthew Rufo,
Yes.
and Candace Forrest. Yes, 5 yeas, no nays. The motion carries. So we'll move that to the end of our agenda.
Okay.
Next item.
We will now begin with new business for variances. Item number 6, BZA docket 06321 was withdrawn by the applicant. The next item is BZA docket 06421 for a property at 3425 Milan Street. Following the staff presentation, the applicant will have 5 minutes to present. Mawako Karate is signed up to speak on behalf of this application. This request is for variances to permit a single-family residence with excessive front yard setback and build to line and a parking space in the front yard. According to Article 11, Section 11.3A1, Table 11.2A, and Article 11.3A3A, the permitted front yard and front yard build to line is 20 feet. The applicant is proposing 48 feet and 7 inches and is requesting a waiver of 28 feet and 7 inches along General Taylor. Article 11, Section 11.3B3, Article 22, Section 22.8B1, Article 22, Section 22.11D1, and Article 22, Section 22.11D2 prohibit parking in the front yard. The applicant is requesting front yard parking, which also necessitates a waiver. Based on this report, the staff recommends approval of Article 11, Section 11.3A1, Table 11.2A, front yard, and Article 11, Section 11.3A2, front yard build to line, subject to 3 provisos. The staff further recommends denial of Article 11, Section 11.3B3, parking pad location, Article 22, Section 22.8B1, permitted vehicle parking locations, front yard, Article 22, Section 22.11D1, parking pad location, and Article 22, Section 22.11D2, parking pad design location. Failed to meet 3 of the 9 criteria for the standards of variance of Article 4, Section 4.6F of the Comprehensive Zoning Ordinance, in that literal interpretation of the ordinance will not deprive the applicant of rights commonly enjoyed by other properties in the district. The special circumstances were caused by the applicant, and the property regulations will not result in a demonstrable hardship. Again, we have Mawako Karati signed up to speak on behalf of the application. I apologize if I mispronounce your name, and you have 5 minutes to present.
Yes, it's Mawako Hattori.
Hattori, okay.
Hi, everyone. Thank you for your time. And can you hear me okay? Yeah, so this project is, client is Broadmoor Improvement Association with finance partner is Community Landship Land Trust. So it's affordable housing, increase, more opportunities. So that's a goal. So it's not a private client. So they have 4 lots, and we had a similar approach to it. And this lot, we thought simply just because existing is all the houses in the block is faced to Milan Street, and use General Taylor as a back street. So the front facade presence is on Milan Street. And because of budget, but also because of create kind of equal opportunity for future owner to enjoy backyard. We appreciate the CPC to recommend that we have a deep setback in the general terrace side. So we have no objections for that, removing parking in the back, and probably we designed to the front facade to accommodate, maybe parking meets under zoning requirements. So we don't have any problem of recommendation. So that's it. If you have any questions, let me know.
Thank you. Are there any questions or comments from board members? I just wanted to confirm, Mr. Torrey, what you were just mentioning is based on the recommendations of staff, it would be a modified approval, and the request related to parking, the recommendation is for denial. And so I just wanted to make sure that, because you were saying that you were fine with the recommendations from staff. So were you saying with that modified approval to deny the request related to parking and to grant the request related to the front yard?
That's fine.
Okay.
We have other prototype to have a parking in the front. So I think we can switch to that prototype. I mean, in a way, they can enjoy back via parking. So we accept that denial.
Okay. Any questions from commissioners?
Well, I mean, I guess my one question is kind of an urban context question. It seems like that whole, whatever that General Taylor Street, the back street of the house, it's a backyard condition all along that whole street. And are there similar examples around the city where you have a house that straddles two streets and people park in the back? I mean, I know Lakeview is different because it's alleys, but it seems like that was the condition before historically, and there's a whole bunch of curb cuts on that street now. So all the neighbors have a curb cut and a yard condition. I'm just curious from staff what it's a backyard, but it's being considered a front yard. So I'm just a little confused about how you approach a site like this.
Yeah, so based on the regulations, that was the only reason why that I couldn't find justification to recommend approval based on those three. I didn't have any, I really do feel like it should be treated as a backyard and you should be able to park back there personally, but based on the CZO regulations, I was not able to determine that they met those three criteria.
So just a quick question. Is this really just being considered a front yard because of
Yes.
the shorter dimension on that side of the block face?
No, it's being considered a front yard because that's the way it's written in the CZO. If it's a through lot, then both yards are considered front yards if they face streets. If there's frontage on two streets, they're both considered front yards. I'll try to find the regulation.
Because I mean, I'm sure I could find.
There should be a note that references Article 26, the definitions.
Yeah.
The definition of front yard. I'm not looking at the report right now, but if you go to Article 26 and look at the definition of front yard, there's a mention at the end of it. It says, on a through lot, both yards that face a street are considered a front yard and are subject to the minimum front yard requirements of the zoning district.
And it's at the bottom of page 4, if you were looking for it.
Is it possible to share my screen?
No, it's not.
No. Okay. Yeah. Can you show the site plan?
So
we have it in our
Oh, gotcha.
packets.
Which sheet, Milwaukee?
Yeah, I think a site plan indicates that, both street, it's very unique street. I don't know if you have the A1.0 sheet we resubmitted.
Yeah, it looks like page 16 in the document.
That's what I was gonna say. It looks like on page 16. It's in the staff report as well, but it looks like page 16 of our packet.
Yeah.
Okay. Well, I was also looking at Google Earth, and every property on the street is a backyard condition with a driveway. So I'm not sure if they're all currently being used as such, but it just seems like an odd example for the city. There are very few examples like this. But that was all my questions.
Okay.
One thing I like to clarify is that also another requirement is to make, back rear side, general terrace side fence to be not opaque, right? That's CPC's recommendation.
Yeah, I don't think we're addressing anything related to the fence.
Okay. So pretty much if it's not opaque, then a choice with this budget will be chain link fence.
Are there any other questions or comments from board members? Seeing none, we can go to the next item.
Okay. We will now begin with the new business for safety and permit decision appeals. The next item is item number 8, BZA docket 06521. This is an appeal of the decision of the Director of the Department of Safety and Permits regarding the determination that the property has not attained legal non-conforming status for short-term rental use. We have Sharonda Williams signed up to speak on behalf of the application, and following the safety and permits staff presentation, you will have 5 minutes to present. The Department of Safety and Permits now has time to present.
Good morning, everyone. My name is Nick Kindle. I'm the zoning administrator for the Department of Safety and Permits. So just for your all information, we prepared one report for the next two appeal dockets. They're both owned by the same property owner. They both kind of deal with similar issues. I'm going to go through the report for each one and just kind of.
I was just going to ask before you begin, Nick, because of the fact that they were, it was one report, is it possible, question for Missy, for us to consolidate items 8 and 9?
Yes, you can make a motion to consolidate under. Did you hear
Sorry,
me?
guys.
Sorry.
I was hearing some beeping noise or some tapping noise. And it was hard for me to look. So what was just proposed that we combine?
Yes, that items 8 and 9 could be consolidated into one item, but we would need a motion from Commissioner.
Happy to make that motion. If in regards to docket 6521 and 6621, I move to combine them into one docket. Is that right?
Combine the dockets into one item.
Into one item. Got it.
Alvarez seconds.
Thank you. It's been moved by Commissioner Diaz, second by Commissioner Alvarez to consolidate items 8 and 9, docket numbers 065-21 and 066-21 into one item. Roll call vote, Todd James may have stepped away. Jose Alvarez,
Yes.
Ramiro Diaz,
Yes.
Matthew Rufo,
Yes.
and Candace Forrest, yes. 4 yeas, no nays, the motion carries. I'm sorry, you can go ahead now, Mr. Kendall.
Okay, thank you, board members. That'll save me from having to read a lot of the same information twice. So hopefully we'll get through this a little bit more quickly. So anyway, to start my presentation, we have 2 appeals, BZA 06521 for 1138-1140, Governor Nichols Street, and BZA docket 06621 for 1205-1207, Governor Nichols Street. So relative to 1138-40 Governor Nichols and 1205-07 Governor Nichols, applicant's appeal alleges an error in the decision of the Director of the Department of Safety and Permits regarding the determinations that the properties have not attained legal non-conforming use statuses for short-term rental uses. Because these appeals present similar issues, relate to similar properties, and are brought by the same applicant, the department has consolidated its response to these appeals in this document. The subject of these appeals are the determination that 1138-40 Governor Nichols Street and 1205-07 Governor Nichols Street have not attained legal non-conforming statuses for short-term rental uses. The applicant had initially applied for a non-conforming use determination for these properties in 2020, and the Director of Safety and Permits determined that the non-conforming uses had not been attained on March 25th, 2020. The applicant submitted additional information in April 2021, and the Director of Safety and Permits made the same determination for these properties on May 14th, 2021, that the non-conforming uses had not been attained. The determination reports for each of these properties are attached to this report. 1138-40 Governor Nichols Street is a 5-unit multifamily residential structure. According to the application documents, the current owner purchased the property in 2015, and affidavits attest that the property had been used for short-term rental uses for 8 years prior to the sale. 3 temporary short-term rental licenses were issued in May 2017, but it does not appear that these were renewed when they expired in May 2018. This property was cited for STR violations 3 times in 2017, 2018, and 2019. The current owner submitted an affidavit that the property has been used for short-term rentals for over 12 years. Prior owner attests that the property was used as a short-term rental for at least 8 years prior to selling the property in 2018. And the owner of a cleaning service business attests that they had cleaned the property as a vacation rental since August 2009. In addition, there were 2010 tax forms noting gross rents in the structures of approximately $23,000, but there is no indication if this is short-term or long-term rent. There were a 2013 and 2020 1009K tax forms that indicated income from Airbnb, but there is no indication what properties or units this income is from. Applicant submitted an appeal from the prior owner indicating 15 different parties of guests scheduled in 2014. There was a March 2016 purchase agreement that indicated that the sales price were above the appraisal due to short-term rental income. For 1205-1207 Governor Nichols Street, this is a multifamily residential structure with either 4 or 5 units. There is no record of any short-term rental licenses being issued at this property. According to the application documents, the current owner purchased the property in 2017, and affidavits attest that the property had been used for short-term rental use for 7 years prior to the sale. The current owner submitted an affidavit that the property has been used as short-term rentals for over 12 years. The prior owner attests that the property was used as short-term rentals for at least 7 years prior to selling the property in 2017. The applicant submitted 1099-K tax forms, but it does not indicate the properties or the dwelling units that the income is from. The applicant submitted a February 2019 purchase agreement that indicated that the sales price was above the appraisal due to short-term rental income for 2 units. These non-conforming use determinations were denied for a number of reasons. Most of these issues are common between both properties, and those items will be addressed first. The first issue is that the short-term rental licenses are issued to individual dwelling units. There has been evidence submitted that the applicant has short-term rental income, but it's difficult to attribute it to a specific property and a specific unit to verify that the individual units have potentially attained non-conforming use status. Second, CZO section 25.3.C.4 states that intermittent or temporary use of land is not sufficient to establish any non-conforming use. Based on the evidence provided by the applicant, there was some sufficient evidence to verify that the short-term rental use was consistent and not intermittent or temporary. While the applicant has submitted evidence and affidavits that the short-term rental use took place for years under the prior owner, there is no evidence that this was a consistent use in each of the dwelling units. The evidence provided outside of the self-serving affidavits is piecemeal and does not show regular annual usage. Third, when an illegal use, i.e. a use that was not established in conformance with the CZO regulations at the time, is seeking a determination that it has attained legal non-conforming use status, it must be done in compliance with the prescription regulations in Louisiana Revised Statutes 95425. With regards to use violations, the prescription period begins when the municipality first had been actually notified in writing of such violations. The applicant did not show that the city had received written notice of illegal STR use 10 years prior to this non-conforming use determination, so the prescription period has not been met. Fourth, prior to the adoption of the current CZO regulations in August 2015, there was no defined short-term rental use. Therefore, before August 12, 2015, all short-term rentals were illegal and prohibited in all zoning districts. If someone was operating a short-term rental prior to August 2015, that use could not have been lawfully established because there was no such thing as a legal short-term rental. In fact, such a use prior to August 2015 would have been a criminal act under City Code Section 54491.1. The applicant is correct that lawful use could maintain its non-conforming use when the CZO changed in August 2015. However, the applicant did not have a lawful use because short-term rentals were not permitted or even legal prior to August 2015. Therefore, these short-term rentals and all short-term rentals would not start their prescription period until August 12, 2015 at the soonest. There are also a few property-specific items that need to be addressed as well. For 113840 Governor Nichols Street, the prescription period applies to the amount of time that the city has to bring enforcement actions on zoning violations. The city has enforced the CZO restrictions related to the short-term rentals with 3 violation cases, including 2 cases that brought judgments against the property in March 2019 and October 2019. This would reset the prescription period for an illegal use. For 120507 Governor Nichols Street, there is no clear evidence or determination of the number of legal dwelling units in this structure. There appears to be only 2 addresses and 2 electric meters at this location. The applicant has indicated that there is either 4 or 5 units in this property, 2 of which are short-term rentals, but there has not been a determination on the total number of legal units at this property. Nevertheless, how many short-term rentals that they are and which units are the short-term rentals. As such, even if there were a path forward to claim a non-conforming STR use somewhere on this lot, which there is not, as demonstrated above, there would be no way for the department to do so, as it could not accurately tie the use to the relevant dwelling unit. For these reasons, the department's decision on these matters should be upheld. And that concludes my presentation.
We have Sharonda Williams signed up to speak on behalf of the applicant. You now have 5 minutes to present. Is she on the call?
Yeah,
It
but it
looks
looks
like
like her
she's
feed may-
frozen.
Yeah.
He was on a second ago. And hey, Nick, if you can, your audio was really like, it sounded like you had a metronome going the whole time. It's really awful.
Yeah, I'm sorry. I'm on my headphones and I share an office with someone else, and I think he was talking in the background during parts of the presentation. So I
No, it's
apologize
something
for that,
else.
and I'm happy to.
Nick, it's something else that's,
Okay.
you got a bad audio connection and it's just like a clapping sound that keeps happening. It's not anybody else in your background.
Okay. Yeah, I'll try to take myself off speakerphone or put you on speakerphone, and that should hopefully help moving forward.
Yeah, I don't know, Mr. Elam, do you have a way to connect with Sharonda? I see her, but we're not seeing where she's, I don't know if she's frozen.
Yeah, I just text. She said she's on the phone, and I don't know if it's about audio. I'm trying to see if she needs to restart.
Yeah. I see she may be trying to reconnect now.
Got it.
So staff will give her, try to give her a minute to reconnect.
Can you guys hear me now?
Yes, we can.
Okay, I'm sorry, I'm dialed in by phone. And so I wasn't being able to unmute by phone unless they prompted it. Anyway, again, Sharonda Williams, I'm here on behalf of Elam Equity Investments. And we've attached a letter to the appeal, but I'll just highlight a few things just for your consideration of this appeal. First, there is a standard, as you guys know, and that we set forth in the letter, for us to provide clear and convincing evidence attesting to the non-conforming status. The director has consistently said that the evidence that's presented is self-serving, but Mr. Elam and Elam Equity Investments has certainly submitted affidavits from prior owners about the use of the property prior to his ownership of them, as well as cleaning services. We've also submitted utility documents, earnings and tax information, and photographs. And the affidavits unquestionably show that those properties were used as short-term rentals for more than 10 years. And there was a non-conforming use that was established, particularly 1138 to 1140. The affidavits show that they've been in use for at least 12 years. At the 1205 and 1207, they've been in use as a short-term rental property for at least 11 years. The department has stated that revised statute 9:5625 gave them 10 years to bring an enforcement action, but it's undisputed that there were no enforcement actions at the 1205 and 1207. And as of 2017, there were permits obtained as to 1138 and 1140. I know that Mr. Kendall said that there were citations that were issued for permit issues on some of the properties, but that matter was already appealed to the civil district court. And the court found that those fines, and some of those fines at least, were duplicative. And notably, in the context of that proceeding before a civil district court, Judge Julian noted that she could not consider the affidavits that are currently before this board, suggesting that if she was able to and had the opportunity to consider those affidavits, then there potentially could have been a different outcome with regard to the use of the properties and the length of time that the properties had been in use for short-term rentals. They've also asserted that because short-term rentals were not recognized or regulated under the comprehensive zoning ordinance until 2015, the 10-year time frame for prescription could not even come into effect until 2025 as sort of a trigger date. That is simply not correct, and it doesn't recognize the fact that the property and that people owning property can certainly use their properties for the purpose of leasing and renting it, and that exists constitutionally as a vested property right, and certainly was something that could have been done prior to 2015 before the city decided to regulate short-term rentals. And those things are set forth in the letter that we've attached. We've cited case law to that effect, and you cannot simply disregard the prior longstanding use of a property by a property owner who's exercising their vested property rights to use their property in the way that was being used prior to 2015. The director has also questioned the tax information that was provided and asserted that somehow there's no way to parse out what income was related to each of these properties, but the question is whether there was short-term rental property income that was related to the use at these properties, and there's no question that the income was related to short-term rentals for the properties. We've added information about appraisals and the rate of or the value of the properties based on the idea that Mr. Elam, who lives across the street from the properties and has actively developed these properties with the intent of using them as short-term rentals, and that was reflected in just the property values. There also was statements about whether the use was consistent such that it could establish a non-conforming use. Well, considering the fact that short-term rentals by definition speaks to intermittent use of the properties in that way, we think that argument by the director is somewhat antithetical to the very definition of short-term rentals and the use that's contemplated. Mr. Kendall also stated that we did not provide clear and convincing evidence that the city actually received written notice of the use prior to 2015 and the longstanding use that was articulated in the affidavits. But again, we've cited in the documents that were attached to the appeal, the legal definition of non-conforming use does not contemplate a notice requirement. It contemplates use, and that is what's set forth in the affidavits. And finally, there's been a lot of discussion about the fact that the use that was done before the comprehensive zoning ordinance was amended to regulate. Sorry?
Williams, that's the end of your time.
Okay, thank you.
Thank you. Are there any questions or comments from board members?
I have questions. So I don't know if Nick, you can answer this, but is the intended use for this property the intent is to obtain legal non-conforming status in order to operate this as a short-term rental under the commercial designation? I'm just trying to understand what's the intent of this. Is it to operate as a short-term rental without having to inhabit the house? Is that the intent?
Yeah, I'm not entirely sure because under the current regulations, this wouldn't fit within any of the permitted categories for a short-term rental. By definition, it couldn't comply as a commercial short-term rental because it's not located in the commercial zoning district, and all the residential types require, a homestead exemption. So I'm assuming that if, they were successful in their appeal and they were granted, the non-conforming use status, that we would have to figure out a way to kind of make the licensing work based on the use. So I'm not entirely sure how exactly we would go about doing that, but we would have to work with our short-term rental license people on that.
Okay, Ms. Williams or Ms. Elam or Mr. Elam, could you respond to that then?
I'm going to let Mr. Elam respond if he can hear, because I'm trying to reconnect again. Sorry, guys.
Hey guys, I'm sorry, I just got back on. Yes, to answer the question, it's very difficult. When I bought these properties, obviously this was nothing that had been approached by the city council as it relates to the laws. And I came in and I renovated one property, and I live directly across the street. So technically, I wouldn't be able to put a homestead exemption on these properties, because my homestead exemption would be in the property that I live in. So it's kind of like a caveat. I guess it would be intended for residential use and not commercial. However, the difficulty is that I can't put a homestead exemption on these properties because I don't live there. But the other side of that, the interesting component to me is that if I sold these properties tomorrow to two separate individuals, they would then be able to put a homestead exemption on them and short-term rental. So it's just kind of difficult for me to understand why I guess I should have to be privy to the current regulations when the initial intent to purchase them was specifically the short-term rental. I mean, this was in the purchase sale agreements of when I bought these properties, and I've spent a significant amount of money to renovate them and redevelop this area. I mean, I've spent $1.8 million on these properties. So it's a big deal for me now to not be allowed to use them with the intended use that I originally had, and for the purpose that I bought them, just because the laws have now since changed as it relates to regulating Airbnb.
Thank you.
Any other questions, commissioners? Okay, we can move on to the next item.
Okay, the next item is item number 10, BZA docket 06721. This is an appeal of the decision of the Director of the Department of Safety and Permits regarding the determination that the property has not attained legal non-conforming status for an office use. Note that the applicant's agent is requesting deferral. I'm sorry. The applicant's agent is requesting deferral to the September 20th meeting in order to provide additional information for safety and permits review, which cannot render the appeal moot. We have Nicole Weber signed up to speak on behalf of the application, and speaker signed up to speak on behalf of the property owner. Following the safety and permit staff presentation, you will have 5 minutes to present, and the Department of Safety and Permits now has time to present.
May I speak?
Hello again.
It's the safety and permits right now, Ms. Weber.
Okay, thank you.
Thank you.
Hello, this is Nick Kendall, zoning administrator with Department of Safety and Permits, and hopefully my sound's coming through a little bit better now. If not, please let me know and I'll try to correct it. So this is an appeal related to 2612 Esplanade Avenue. This is BZA docket 067-21. Relative to 2612 Esplanade Avenue, the applicant's appeal alleges an error in the decision of the Director of the Department of Safety and Permits regarding the determination that the property has not attained legal non-conforming status as an office use. The subject property is in an HU RD2 two-family residential district where an office is a prohibited use. This determination was made by the Director of Safety and Permits in a report dated May 27th, 2021. The complete report is attached to this document and is summarized below for your reference. 2612 Esplanade was historically a single-family dwelling. The property owners purchased the property on March 23rd, 2011, and moved their business, Horizon Tours, Inc., to this property. On August 15th, 2012, the property owners moved to 2914 Esplanade, but kept their business at 2612 Esplanade. According to the applicant, the business has continued operation at this location until this time. The applicant has submitted leases, affidavits, use history, utility bills, and internet business listings in support of this request. Based on the city's records, there was no evidence of this property was used as an office. There was a 2017 building permit for exterior repairs to this building that indicated the property was a single-family residence. Also in 2017, the property was issued a short-term rental license that expired on May 29, 2018. There were no records of any occupational licenses or applications in LAMA, the city's permitting and licensing database. The non-conforming use determination was denied for a number of reasons. First, the city's records for this property indicated that the use was residential until at least 2017-2018. There was a building permit that indicated that the use was single-family residential, and there was a short-term rental license for this structure, and by definition, a short-term rental is located in a residential dwelling unit, and a short-term rental license could not have been issued to an office. Second, when an illegal use, i.e. a use that was not established in conformance with the CZO regulations at the time, is seeking a determination that it has attained non-conforming use status, it must be done in compliance with the prescription regulations in Louisiana Revised Statute 95625. With regards to use violations, the prescription period begins when the municipality first had been actually notified in writing of such violation. Based on the evidence provided and in LAMA, there is no record of the city receiving written notice of this violation until we received this non-conforming use application on April 29, 2021. In fact, all the evidence has indicated that this structure was residential use in 2017 and 2018. The applicant states that they had attempted to apply for an occupational license a couple of times, and either the application was not accepted or that they were told that they needed the proper zoning. An occupational application is a request for permission to operate a business in a particular location, which is different from evidence that an illegal use is taking place. There is no evidence that the city had noticed that despite their inability to successfully apply for an occupational license at this location, the business continued operating illegally. Finally, documenting that there is an office use in a residential structure is not enough to attain non-conforming use status. The city approves occupational licenses for many offices in residential districts as home-based businesses. If they comply with occupational requirements in CZO section 21.6.R. The limitations require that the home-based business is accessory to a residential use, that is, the business owner resides in the dwelling, and limits the employees to residents of the dwelling. It is possible that this business was operating as a home-based business for at least part of the time, such as when it was first purchased in 2011, prior to moving to 2914 Esplanade Avenue in August 2012. However, the applicant has not raised this argument, nor have they submitted adequate documentation to demonstrate that this is the case for this property. For these reasons, the department's decision should be upheld. And that concludes my presentation.
And Nicole Weber, you now have 5 minutes to present.
Good morning. I'm not going to refute or rebut any of staff's comments. What I would like to do is ask for a deferral to the September 20th meeting, and that will allow us to continue further communication with the city on this matter, and with the objective of providing additional information that will allow us to withdraw the application or the appeal, I should say.
Okay, thank you, Ms. Weber. Are there any questions or comments from board members? And Ms. Weber, you understand that we'll still have to go through the latter portion of the meeting in the event that there are any public comments, but we'll consider the request for deferral after public comment if there are any.
Yes, thank you.
You're welcome. Okay, we can go on to the next item. I think this is the last item.
That's the last item, and we will discuss the election of officers after the recess, correct? Okay. So the comment card was not turned on at 10 o'clock. And I believe that Emily is consulting with Missy right now to find out if we need to allow additional time during the recess for the comment card. For public comments, right?
Yes, so the comment card is now turned on. It's been turned on for about 20 minutes. And Missy's suggestion was to extend recess about 10 minutes to allow for, people to submit their comments through the form.
Okay. So should we say,
So we can just,
normally we would be at 11:40, would be 30 minutes. So is it going to be about 11:50?
Yeah, just to compensate for that extra time, I think out of an abundance of caution, we should just add a little extra time for people to comment.
Sure.
So Chairwoman, just even from that standpoint, just to kind of have a good, safe, even start time, do we just reconvene at noon?
That's good.
All right,
That way I don't have to wolf down lunch.
there we go.
thank you. Well, this concludes the presentation of dockets. The board will now recess until noon. Consideration of dockets, including public comments, will begin at noon. Please refer to the screen for public comment rules, and public comments will be accepted until the close of the recess. Would the board consider a motion to recess until 12 o'clock noon?
I, Todd James, will move.
Rufo, second.
Alfonso, second.
We got a few seconds. It's been moved by Commissioner James. I think I heard Commissioner Rufo second first. Roll call vote, Todd James,
Yes.
Jose Alvarez,
Yes.
Ramiro Diaz,
Yes.
Alfonso Gonzalez,
Yay.
Matthew Rufo,
Yes.
and Candace Forrest, yes. 6 yeas, no nays, the motion carries. We'll be in recess until 12 noon.
All right, looks like we have quorum. So let's go ahead and get started.
Would the board consider a motion to return from recess?
Todd James, so move.
Alvarez seconds.
It's been moved and seconded. It's been moved by Commissioner James, second by Commissioner Alvarez to return from recess. Roll call vote. Todd James,
Yes.
Jose Alvarez,
Yes.
Ramiro Diaz, Alfonso Gonzalez,
Yay.
Matthew Rufo,
Yes.
and Candace Forrest. Yes. 5 yeas, no nays. The motion carries and we're back from recess.
Okay. The public comment forum is now closed, and we will begin with the consideration of dockets and the public comment portion of the meeting. However, I do want to confirm that we have received no public comments. Is that correct, Emily?
That is correct.
Okay, I got an email from Valerie M. A text from her. So, all right, so we're going to move on. Items number 1 and 2 have been withdrawn by the applicant, and we will move on to the third item on the docket, which is item number 06021 for a property at 2315 through 2317 North Robertson Street. This is an after-the-fact request to permit the conversion of a single-family residence to a two-family residence and an addition with a porch with insufficient setback from a side lot line. As a reminder to the board, the staff recommendation is for denial.
Thank you. Any questions or comments from board members? I believe Commissioner James had a couple of comments from earlier, and I had some similar questions. The main question that I had was just related to the 9 criteria, specifically related to a demonstrable hardship. And there was just nothing in the communication that was submitted that indicated that there would be a hardship by not granting the request. And so that's just a question to the applicant, if there was anything to add on that particular point. You're on mute, Mr. Muhammad.
Yes, thank you, ma'am. Well, the whole reason the platform, the landing is raised because of the elevation of the new building is required that height, and it is already poured in concrete. So I request it will cost not only more money, but it will also take time and money, which it is hard on me after investing all that money into it. So I request board members to please allow to be that way. And if there is any inconvenience in future, I will consider later if you guys allow me to.
And just to add a point of clarity in relation to demonstrable hardship, the financial impact is not one of the reasons that we consider in demonstrable hardship. So I just wanted to make mention of that. I know that's one of the points that you brought up, but the financial aspect is not one of the considerations when considering a hardship.
Okay. It just allows that elevation to match, and it actually doesn't come in the way of firefighters if they have to get access to the back of the building, and any for the rainwater to run off, that has a crawl space underneath it. And it is just going over 1 foot 2 inches. So I request board to consider and allow me to have this time.
So just a question to the applicant. So what's the justification for having those doors along the side of the property?
That way it will be close to my old house, which is sitting on the ground, which is having a lower elevation, and it is approved. So that way I can close to my old house and new house.
But again, what's the justification for having those doors along the side? I'm not following why that is necessary.
That is the whole reason was to just have near to my existing building. If not, then I have to walk all the way around to the back, and the front house is like almost 40 feet, and again this is another 30 feet. So why walk from there when I have the access? I have my main entrance is on the front of the house, but I use my side entrance, and that way I have already using for the existing house, I have a side door. So that's what I use to get into the house.
Okay, but you have 3 doors along the side to get into a single unit.
Yes, sir.
Why?
Just more convenience for me. I have my old parents, and it's just a convenience. It is elevated, sir. Even though if I have 1 door, still I need.
I'm very
steps
clear
to
of why
get.
it's elevated by code. I understand that the flood elevation requires for you to build a unit at a certain height in some cases, but then again, that would actually cause for you to elevate the entire property and not just this addition.
I took a variance on that one, sir.
Okay, so you took that's for your existing structure, but you're now
Yes, sir.
building a unit in the back and an elevated height, but then providing 3 doors along that side, which if I'm looking at this plan, and once this was completed, I could see how this plan could easily be modified to be created into 2 separate units on the first floor, as well as a stair that comes up to a unit upstairs, which is not really clear on how that's being ingress or egress, or what type of layout is actually on the upper floor. So what I'm concerned about is creating or granting some type of waiver or variance based on a plan that really kind of supports something that actually is out of compliance with the code as well. So while we're not necessarily reviewing that if this is a multifamily structure, if we were to grant this for you, we would be creating a path of something that could remain and move forward unchecked. And that's my bigger point of concern. Also, it doesn't really seem to add up because you could have just had 1 entrance off the backside in order for this to be configured as a second unit, where you could provide a code compliant porch and not have an elevated structure inside of the setback area. So this is not necessarily just about access into the building. This does get into stormwater. This does get into other elements where you're basically creating a non-permeable area within the side yard, which falls outside of the requirements of the code. I just see too many things that I hear that did not really, it doesn't smell right to me when I'm looking at what's in front of us.
And Todd, if I can just jump in and let me just add one thing to that. Just reviewing the plan as we normally do, like if we see options for other ways to do this, we have a hard time meeting that hardship requirement. So you could very easily add a door through the laundry room that would get you up to that back apartment if you're looking for direct access. That's a connection, or through the den. You've got two ways that are connected to the back there that would get you an easy connection to that back apartment without going outside, if the reason is that it's a short distance to go out that door. And then, as Todd says, I see a way to add an entrance to the back of the building there that does not, you don't need to have the side porch for that to work. So there's 2 ways to fix this in plan as far as I see it. And, Todd's bringing up valid points as well. So as we review these things, we look at all the options and the opportunities here, and there's many.
Yes, yes, James, and thank you for suggesting me that. But what I still request is, with all due respect to Todd also, this is just my convenience. I have door, and for that variance, which my landing is, I'm not having exactly 2 feet, but I have only 10 inches. Is that okay if I just trim 1 foot 2 inches so that still it will have 2 feet of the clearance?
Well, then your landing would be out of compliance with code in order for its width for you to ingress and egress. So again, we can't just keep negating the code on one side in order to create another non-compliant element somewhere else. But back to Commissioner Diaz's point, it's when we get to these plans and we see other ways of how these plans could come into compliance, it's really hard for us to justify anything else. And you're also establishing the financial hardship. Again, that's not how we traditionally review these. And that's actually pretty strict language within the 9 criteria that shows some level of non-compliance for us to grant a waiver of variance.
So Mr. Todd, can I have, how can I keep the door and still have steps? Because I have like 4 feet and I can have 3 steps. You just don't like the landing. I still need 2 steps.
I would suggest that you talk to whoever the professional of record is that did these plans for you and identify what is within code compliance. And I'll just say this is not really a negotiation element here. We have to adhere to what's within the zoning ordinance. And again, I'm just very apprehensive when I see these type of plans come in with something that could seemingly create a bait and switch format of how this plan is being submitted.
Well, today I'm here for the variance, and if there is anything I can do so that I can resolve this issue and move forward, I will appreciate all the board members, and I will be thankful. And I waited for this meeting to just to bring this inconvenience and this issue. So please recommend me, or living financial hardship still is going to take time and going to alter so many things. But if that is how I have to go through, then I will request and discuss with the engineer to have individual steps or some kind of way.
Just a quick question for you. Is it your intention to rent this unit or units?
This is for me, and I have my aged parents, so this is for my family. But if all goes well, I will have my family member live in the front part of the house. But the new house, we want to enjoy it.
Madam Chair, I don't have any other questions.
If there are none, is there a motion?
If no one else has any other questions.
No, you can proceed.
All right, Madam Chair, with regards to docket number, with BZA docket number 060-21, my motion is to acknowledge the staff's recommendation with regards to Article 21, Section 21.6.AA.1 for porches, steps, and stoops inside that encroachment, and move for denial, understanding that the 9 criteria have not been met. I would also just put a notation. I'm gonna ask staff to put a notation with safety and permits just to confirm that this is not a unit that will further expand into a further nonconformance, and that the applicant needs to try to establish a plan that comes into further conformity.
And I'll second. Ramiro.
It's been moved by Commissioner James, second by Commissioner Diaz to uphold the staff's recommendation and deny the requested variance, finding that the 9 criteria have not been met. A roll call vote, Todd James,
Yes.
Jose Alvarez,
Yes.
Ramiro Diaz,
Yes.
Alfonso Gonzalez,
Yay.
Matthew Rufo,
Yay.
and Candace Forrest, yay. 6 yays, no nays, the motion carries. Next item.
Okay, item number 4 was withdrawn. And we will move on to new business for variances. Item number 6 was also withdrawn by the applicant. Item number 7 is BZA docket 06421 for a property at 3425 Milan Street. This request is for variances to permit a single-family residence with excessive front yard setback and built to line and a parking space in the front yard. As a reminder to the board, the staff recommendation is for approval of the front yard setback, built to line, and denial of the front yard parking.
In 15 minutes.
Comments?
And if we could mute Mr. Muhammad's line.
Are there any questions or comments from commissioners? I believe Mr. James and Mr. Diaz had some discussion on the front yard designation. So
Yeah.
I don't know if you still needed to address that.
I'm sorry, and I know I had jumped off the meeting for a second. I had a little work emergency I had to tend to. And the question I was actually asking of staff at the time was, I know that Valerie, I think Valerie, you were given mention at the time about how it's from reference to Article 26 in the code. And if you don't mind, just kind of revisiting that reference again.
Yes, so the definition for front yard, and let me just go to it.
And it's on page 4.
Yeah, it's at the bottom, yeah, in the notes at the bottom of the page. But the definition of front yard, at the end of the definition, it says on a through lot, both yards that face a street are considered a front yard and subject to the minimum front yard requirement of the zoning district. So that is the only reason why it's considered a front yard and not a rear yard.
But also when we get into that same definition, I thought it also got into the shorter length of what fronted that street. So in this case, like when I'm looking at that and looking at some of the geometries of this site, the longer frontage is actually on the Milan Street side as opposed to General Taylor.
The Milan Street side should only have an 8-foot setback, I believe.
I'm not speaking to setback. I'm talking strictly the length of the actual property line. When I know that, so I know that we've had that consideration as well. So if a lot is maybe 30 feet at the front and if back of it's wider, that the frontage is always granted to that shorter lot dimension, especially when we're looking at corner conditions. And when you see that type of application, in this case, I'm taking that the General Taylor side of the property is actually elongated property frontage. So that could actually help to posture the conversation that that side of the lot is actually more of a rear yard dimension as opposed to a front. I know we have to fall to the pure letter of how Article 26 is written with frontages, but that may help to push the conversation a little bit in a different direction to help further what the applicant is presenting, especially when they're holding a true frontage on a Milan Street side in character with the block face. And almost wondered if there was a condition where proviso was put in place for them to fence off the back of the property to some level in order to screen off where that parking was being provided. Is that not another mechanism that could actually help to support the request as proposed?
If I could comment, I believe the plans that were originally submitted for this application included a fence along that General Taylor lot line. However, since the CZO considers that a front yard, it would need to be an open fence, which means 50% or more would have to be open in the required front yard and forward to that lot line. Yeah. And the applicant, I believe, chose to remove that from the plans. But the board, could consider suggesting or including a proviso to, to have an open fence on that side of the property.
Well, Todd, if I can jump in, the question about kind of the urban character of it and whether it makes sense to have the parking in the front and the back, and going back and looking at it a little more closely, there's a lot of front yard parking on the Milan side. And there's also a new house down the street that has that little L shape that gets the parking in. So it wouldn't be odd to have the parking on the front. I had only looked at it in plan and thought it was a bunch of shotguns in a row, but it looks like it's that shotgun type with the parking in front. So if Milwaukee had an alternate plan and was, I don't know if she's still on the call, I can't see everybody.
Yeah, I'm here.
Yeah, I mean, if you had another route, as you indicated earlier, we could move to, if you're okay with it, we could move to to do the partial approval with the denial for the parking.
Yeah, one thing I would like to mention is that we want to provide the security in the backyard. So definitely chain link fence, it needs to be provided. But besides that, I think we can go either way. The chain link fence and the transparent gate for car to come in the back, or we can modify the design to accommodate parking in front. We can go either way.
God, you're making faces. Do you have something you're
I was just about to
ask
ask
her?
if there was any response or thoughts. I know the two of you kind of brought up the questions on the yard. I don't know if that kind of satisfied you, or if you Todd still looks like
I always look like I'm confused. This is nothing new, y'all. Come on. No, I'm making faces because I'm sitting here trying to figure out something. But I mean, it's really up to the applicant and their representative, what they deem necessary. I don't want to push something otherwise.
I think if it's just because, this is, again, that Broadmoor Improvement Association is to try to sell property. So we can go either way, but if they can if you give opportunity for them to make decisions, so either, the parking in front, or that the General Taylor side, still parking is acceptable, but we'll provide chain link fence, so it's transparent. Maybe ideal situation is for us to have a choice, but again, we can go either way.
I think the 50% transparency that they're speaking to doesn't necessarily mean that it has to be chain link. I mean, I think there's other, I think Emily, tell me if I'm incorrect, that's also just tied to maybe the spacing of pickets. If you had a slat fence.
Yeah, the way that safety and permits has determined, if you have your kind of standard 7-foot wooden fence, for example, the removal of every other slat would meet that 50% open requirement, as an example.
Right.
Okay.
Just making sure that all options are being explained.
Yeah. I think we can do that way. We need to run, budget, but should work. We just want to make sure, security in the backyard for the future tenant and owner.
Commissioner Diaz, tag, you're it. I think this is, I'm gonna take your lead on this one, man.
Well, I mean, judging by our normal kind of, or at least my metrics here, there are options, right? So you could do it another way, but I do understand that there are some urban, considerations here, that the site has some history and there was access from the rear. So I don't know, Milwaukee, would it be helpful? Do you want to go back and talk to your client about this and decide if it's better to change the design, or do you want to just accept what the staff recommendation was? Because I could see it both ways. I mean, you've got a lot of parking on Milan Street right now, so it wouldn't be out of character for it to have the parking in the front.
Okay.
On
Well,
Milan.
maybe simplest way is that to put the parking in front. And it's gonna be a little bit, L shape in the front. Parking will be side, but will meet zoning requirement. So that I want to make sure that doesn't trigger another zoning requirement. So I want to make sure Todd, Breakman is okay with that. And if he's okay with that, we can go to the route. If he's not okay with that, we like to have permission no parking in the rear.
So should we defer this then to give you guys time to hash it out a little bit? I think it seems like that would be the smart move here.
Okay, sounds good.
And I think Malako, just think of pay attention to on the time clock. I know staff would need to see this pretty soon, so I'm not sure how quickly you'd be able to turn this around back to them so they could review it accordingly.
Okay, understood. So we like to be in the next agenda, which is like 1 month away, right? Or 2 weeks
Correct.
away, 1 month away.
Yeah, and I think the staff will need to see something within a week from you. Correct, Emily? Or Valerie, you're the one who's doing the report, so you're the one who has to check it, right?
Yes, something by next week would be good, by Friday of next week.
Okay, will do.
Thank you.
Any other questions, commissioners? Seeing none, is there a motion?
So in regards to docket 6421, I move to defer for 30 days so the applicant has time to get back with their client and look at other options.
Hi, Todd James, so move. I'm a second, sorry.
It's been moved by
Jumping
Commissioner.
all over the place.
It's been moved by
All right.
Commissioner Diaz.
Thank you for your time.
Thank you. Second by Commissioner James to defer the matter 30 days. Roll call vote, Todd James,
Yes.
Jose Alvarez,
Yes.
Ramiro Diaz,
Yes.
Alfonso Gonzalez,
Yay.
Matthew Rufo,
Yes.
and Candace Forrest. Yes. 6 yeas, no nays. The motion carries. Next item.
I believe that I have skipped an item. Hold on just a moment. Yeah, I did skip item number 3. So BZA, the next item is BZA docket 060-21. I'm sorry, did we do that one? Okay, I'm sorry. I don't know what's wrong with me. I completely forgot we did do that one. That was with Mr. Muhammad. Okay, all right. So we are moving on to the
Decision
unfinished
appeals.
business. I'm sorry.
We should be on decision appeals, correct?
Yes, we are. Let's see, I don't know why my brain stopped. All right, as a reminder to the board, we combined items number 8 and 9, BZA dockets 065-21 and 066-21 into one item. So items BZA's item number 8 and 9, BZA dockets 065-21 and 066-21 are both appeals of the decision of the Director of the Department of Safety and Permits regarding the determination that the properties have not attained legal non-conforming status for short-term rental use.
Are there any questions, commissioners? I do have I was just trying, Mr. Kendall. I know that the applicant brought up a couple of points related to the timing for the attainment of non-conforming status, legal non-conforming. And I believe the applicant's representative time may have run out. And I actually had a question about that. So Ms. Williams, if you're still on, I just wanted to get the remainder of the comments related to the timing of the legal non-conforming status. So I was just trying to understand the applicant's specific position on that point.
Yeah, y'all go ahead.
I'm on, guys. The only other comment that I wanted to make was about the references to it being illegal. There were repeated references to that, and I just wanted to point out the fact that we've cited in the papers the case law about constitutional rights and use of your own property to lease property and dispose of it in any way that you see fit. So Mr. Kendall repeatedly stated that there was no ability to have a legal use of the property prior to 2015, which is contrary to the Constitution. So to that extent, we've submitted the affidavit showing that they were in use in a legal non-conforming way prior to 2015 for the requisite number of years to establish a non-conforming use.
Ms. Williams, the applicant's position is that the 10-year period you're contending that the 10-year period is met because of the use prior to 2015?
Well, that's correct. We submitted the affidavit showing that 1138 and 1140 was in use for at least 12 years, and 1205 and to 1207 was in use for at least 11 years. And I think we've submitted affidavits from the prior users showing that prior to Mr. Elam's purchase of the property, it was being used for at least 8 years in this way before that.
Mr. Kendall, I'm just trying to follow the frame of reference on this, and it's just a little bit confusing to me. So, Mr. Kendall, the department is indicating that legal non-conforming status can't occur until 2025, or was it 2028? I'm missing the year.
So when we do any sort of non-conforming use determination on these sort of things, we need to go back and look at the past legal history of the property. And so I would contend that this was an illegal use. Certainly a property owner has a right to use their property legally. They would be able to use the property as a long-term rental unit, but there was nothing in place that gave this property a legal right to operate it as a short-term rental during this time. So the use was never lawfully established. The comprehensive zoning ordinance had prohibitions on leasing residential properties for less than 30 days. The criminal code had similar restrictions that didn't allow for properties to be rented for less than 30 days. So it wasn't until 2015 when there was even an option on the books in the city of New Orleans to have a short-term rental. So any short-term rental prior to 2015 would be by definition an illegal use. And so certainly we look at non-conforming use determinations differently based on, how the use was established. If it was something where, the use was allowed and then the zoning changed, in 2015, when the comprehensive zoning was updated, that use can be maintained because it was legally established. In this case, the use was not legally established. So yeah, I think it is our position that, if you were claiming that you were that you had a non-conforming short-term rental, it depends on where the property is. Certainly, because prescription depends on if the property is in a local historic district versus not in a historic district. So properties that are not located in the historic district that were in operation in August 2015 could prescribe, I think, as soon as August 2020. Properties that are not located in, or that are located in a historic district, cannot prescribe until August of 2025.
And then now that the law around short-term rentals has changed, that's further complicating the attainment of legal non-conforming status with this property as well, correct?
I mean, certainly the short-term rental laws have changed a couple of times, but I don't think that really impacts our decision here, because the property prior to 2015 was not a legal use. And even though this property, I think, for a certain period of time was able to get temporary short-term rental licenses, those licenses are things that could not vest property rights. They were set up as temporary uses. So that was something that was supposed to be temporary, intermittent. It was not supposed to take place for more than 90 days a year. So that would have been something that would never be able to vest property rights as a short-term rental. So I don't really think there is much of an argument that this illegal use could have vested, this property rights as a short-term rental.
Okay. Thank you. Any other questions, commissioners? Mr. Rufo, I know you had brought up some points in the first discussion. Just wanted to make sure that there weren't any other questions or comments from the board.
Thank you, but no, everything seems pretty clear to me.
There are no other questions. Is there a motion? And just for clarity, Missy, since we've consolidated them in terms of when we make a motion, would we still need to make a motion on each item, or do we just reference it as the consolidated items for 065 and 066-21?
If you're going to vote the same way for both of them, it would be a consolidated, but if you're going to go different ways, then you would have to do it separate. But I think the purpose of consolidating this was to make one decision since they're both the same facts.
Got it. Okay. Thank you. If there are no other questions from the board, is there a motion?
Just a quick question. How have we, Missy, if you have a better sense of just our past decisions on similar properties like this. I know we had a project like this on Carondelet, as well as some other properties that had very similar situations. What has been the precedent in the past, if you feel comfortable speaking to it?
Don't specifically remember that one.
I just remember the entire conversation around temporary became a large driver in how we've ruled on these items in the past. Nick, do you have any recollection of that? Was that a consideration in your review?
I don't specifically recall the facts around Carondelet either. I don't know. If Ashley, who's also, I think, on this call, if she remembers anything related to that.
Hi, board. Ashley Becknell, Chief Zoning Official. I don't specifically remember that one. In this case, the fact that any permits that would have been received were temporary and therefore were designed by the council not to vest a non-conforming use in the property would certainly come into effect. But here we think even beyond that, there hasn't been a showing that these properties have attained a non-conforming use. So we don't think that the evidence exists to show that they've overcome the issue of the criminal code provision that prohibits rental in certain areas for less than 30 or 60 days, depending on where you are. Plus, there is the issue of, yes, temporary permits that only allow you to operate 90 days a year cannot vest a non-conforming use, and that is by design.
And I think that was actually where my question was stemming from. I know I was kind of in and out of the call on the first half, and that was why I was asking. I just remember we've had that in the past as a topic of discussion.
Yeah, I was just gonna echo what Ashley and Nick both said. That was kind of the gist of my recollection, was around the temporary nature of the short-term rental permits. Couldn't vest the right, and so that was, kind of part of the thought that I was thinking through, asking Mr. Kendall some of the questions that I was asking, and just trying to remember the situation as it had come up before. Not claiming to remember verbatim, all of the details when we've had this come up previously, but that was the recollection that I had related to those temporary permits. Any other questions, board members? Seeing no questions, is there a motion?
Todd, are you doing it? You're unmuted. Not, I'll do it. All right. In regards to dockets 6521 and 6621, I move to, oh God, the language I don't have in front of me. I move to uphold the decision of safety and permits. And I am blanking on the rest of what I need to say. Is that enough?
Finding that there was no error in their decision.
Finding that there was no error in the decision. Apologies. Yes.
Alvarez seconds.
Thank you. With regards to dockets 065-21 and 066-21 consolidated, it's been moved by Commissioner Diaz and second by Commissioner Alvarez to uphold the decision of the Department of Safety and Permits, finding that there is no error in those decisions. Roll call vote. Todd James.
Yes.
Jose Alvarez.
Yes.
Ramiro Diaz.
Yes.
Alfonso Gonzalez.
Yay.
Matthew Rufo.
Yes.
And Candace Forrest. Yes. 6 yeas, no nays. The motion carries. Next item.
Okay, the next item is item number 10, BZA docket 06721. This is an appeal of the decision of the Director of Safety and Permits regarding the determination that the property has not attained legal nonconforming status for an office use. As a reminder, the applicant's agent is requesting a 30-day deferral.
And I'm not seeing the applicant's representative. I just wanted to make certain, just given the timing that we brought up in the earlier request for deferral, that the 30 days would be sufficient, because I believe she wanted to have some additional conversations and may have additional documentation to share. So I don't know. I mean, I'm fine with considering a request for a 30-day, but just wanted to be sure that that was sufficient.
I think if they need to, they could likely just communicate to the board if they need more time, and we could just, if they need to do the extension. Nick, were you going to say something?
I was just going to say that we have no objection to the deferral, and I don't have specific knowledge about what sort of evidence they want to present. So I would assume 30 days is probably enough, but certainly if additional deferral is needed, we're good with taking that extra month if we need it.
Okay.
Actually, didn't she say September during her comments?
She had specifically requested 30 days.
Yeah, I do remember her saying September. Okay. She gave the September date.
Yeah, okay. She did.
Thank you. Was there any, I can't say if there's any questions because the applicant's representative is not here, but is there a motion from the board?
I'll jump on that one. No. Madam Chair, with regards to BZA docket number 067-21, my motion is for a 30-day deferral at the request of the applicant's representative. Aye, Todd James.
And Alfonso
second.
All right.
Oh,
It's been moved by Commissioner James and second by Commissioner Gonzalez to defer this matter 30 days at the request of the applicant's representative. Roll call vote. Todd James.
Yes.
Jose Alvarez.
Yes.
Ramiro Diaz.
Yes.
Alfonso Gonzalez.
Yay.
And Matthew Rufo.
Yes.
And Candace Forrest, yes. 6 yeas, no nays, the motion carries. Next item, I believe, is the consideration of officers.
Yes. Mm-hmm. It is.
All right, so are we staying the same route? Are we staying the same course? Or anybody want to jump up and start, having a little bit more fun? I mean, otherwise, I would move to.
I like to move that.
Go ahead.
Yeah, I was just gonna say, I'd like to move that the fun stays kind of where we are. Madam Chair remains Madam Chair. Mr. Vice Chair remains Mr. Vice Chair for another term, and That would be my suggestion, recommendation, motion for the board.
And if y'all are okay with that, I support that as well. I certainly can't even get Robert's rules right, so I have no desire to. I can't get the.
Don't admit that
no
on
chance of me
on the record.
volunteering right now.
Hey, it's job security for me.
It's always great to just defer to Madam Quickly whenever necessary. But we have a motion by Mr. Gonzalez, Commissioner Gonzalez, and a second by Commissioner Diaz for the, it always feels weird when I'm saying it on behalf of myself. But for the chair to remain as myself, Candace Forrest, vice chair would be Commissioner Todd James. Roll call vote, Todd James.
Yes.
Jose Alvarez.
Yes.
Ramiro Diaz.
Yes.
Alfonso Gonzalez.
Yay.
Matthew Rufo.
Yes.
And Candace Forrest. Yes. 6 yeas, no nays. The motion carries. And
So
thank you for the vote of confidence from my fellow board members.
Same here. And my appearance of apprehension is more in jest than anything else. Y'all know I enjoy doing this with y'all everyone. So.
Alrighty, at 12:48, would the board consider a motion to adjourn the meeting?
I think I'm about to shed a tear because I don't know if I've ever seen 1 p.m. ever in my life as a member of this board and being free. So I, Todd James, so move to adjourn.
Second, Alfonso.
Been moved by Commissioner James, second by Commissioner Gonzalez to adjourn. Roll call vote, Todd James.
Yes.
Jose Alvarez.
Yes.
Ramiro Diaz.
Yes.
Alfonso Gonzalez.
4-1, yes.
Matthew Rufo.
Yes.
And Candace Forrest, yes. 6 yeas, no nays, and we are adjourned at 12:49 p.m. Wow, wow, wow. Thanks, everybody. Enjoy the rest of your day.
Have a good one.
Thank y'all.
Thank you.
See you next month.